Hooray for Hollywood. Okay. All right. So let's get started. So yesterday we learned about this idea of asmachta applying to a situation where a debtor makes a partial payment. And then he says, if I don't pay the balance by, let's say, February 1st, you can go ahead, he tells the escrow holder, he says, you can go ahead and give the original promissory note back to the creditor so that he can collect the full amount. So that you shouldn't do, because the debtor doesn't really mean it seriously. He only means it as a way of expressing his absolute certainty that he's going to come up with the money in time. And then unfortunately, if he doesn't, so then, he didn't really mean it. Then we saw yesterday that if he enacts it in Beis Din and has the authorization of Beis Din that he's meant to be taken seriously, then it can be taken seriously, provided that there was no onus. That's what the Imrei Yaakov had added. Provided that it's not like he had the money in hand, had attempted to make the trip to pay it back, and then got stuck somewhere. Okay. So let us continue. Bamed dvar mamurim, the davar yadua sha'asmachta hizu v'lo gamar v'hikna. He says, up until now, what we've said is that's only true if the circumstances indicate that what his statement is meant to be taken as an asmachta, that he doesn't mean it seriously.
The Rabbi frozen? Yeah.
Or maybe there's uncertainty whether there will be a claim of asmachta. And we're not sure because it's possible. Yeah, I know. Because maybe he did mean to commit himself with a full heart to that statement. Because he knows that he is liable. Va'afilu im yadua sheyesh lo eza taina, ela she'eno yadua l'shalish im yizke ba'hala b'din. He says, or let's say the creditor has a valid claim to getting back the promissory note, but he doesn't know, the escrow doesn't know if he'll get it or not. So there's a lot of ambiguity in this text. Let's take a look at the Imrei Yaakov. He's going to explain what's going on over here. So if you take a look at where he says over here, Misupak, he's in doubt. Ketzat, what's the illustration? Hare Reuven hayachayev l'Shimon kach v'kach. Reuven owes Shimon a certain amount of money. Let's say it's $100,000. V'hishve atzmo imo sheyifr lo chovo al zmanim. And Reuven makes an arrangement with Shimon that he's going to set up a payment plan, kagon tashlumim chodshiyim, let's say monthly payments, okay? V'hifkid Shimon hashtar biyad Levi. Shimon, who's the creditor in this example, gives the promissory note over to Levi, who's the escrow holder. V'hisna imo, she'im lo yifra lo Reuven zman echad, tashlum zmani echad. He basically makes a stipulation that if Reuven doesn't pay me, is if he's late even for 1 month's payment and he doesn't make a monthly payment, yachzir lo Levi shtaro v'yigba hakol b'pam echas. Then I have the right to collect all of the entire amount in one lump sum. In other words, basically what Reuven, according to Shimon the creditor, he claims to Levi that Reuven promised that he'll make monthly payments by the first of the month to pay back the debt. And if he ever misses a month, I get to collect the full amount that he was originally liable, and I get to do it all in one fell swoop. B'Shimon lo para lo zman echad. So he's making, I think he made a mistake. He means to say Ruvain. I think he got his names mixed up over here. So we'll use our illustration. Ruvain is the creditor always in our illustrations. Shimon is the debtor. Shimon neglected to pay 1 month. So Yachzor lo Levi shtaro. And so by the terms that were set up by Reuven and Shimon, Levi should give the shtar to the creditor. Afal bi sheyiyu l'Shimon tainos alzeh, even though he knows that Shimon the debtor is going to have a grievance. Mikol makom eino Levi lachush lazeh, ki harei eino dayan bedavar, rak shalish, because Levi is not the judge. Levi is simply the escrow holder, and he has to obey the escrow instructions. Lachein yachzor l'Ruvain shtaro, and that therefore he should give to Ruvain back his promissory note. Ach terem sheyotzienu miyado yomar lifnei ha'edim ha'inyan k'mo shekasav harav behemshech. But really, what this seif is addressing is let's say, the ethical dilemma that Levi has in giving the promissory note back to the creditor. He knows full well that the deal that was struck between both the creditor and the debtor is, and these were the instructions that they gave him when they gave him the promissory note, is that in the event that Shimon, the debtor, misses 1 payment, Reuven gets back the entire note. And Levi is disturbed by this because he knows that this means that the debtor is going to have to pay a huge amount more than what he was originally liable for. So in that kind of situation, this is what we're saying, is that the escrow holder, Levi, should say in front of witnesses, I am returning the note to Reuven. He's already collected, let's say, 1/3 of the debt. But because the debtor failed to pay 1 month, I have to fulfill the terms of my escrow instructions, and I have to give the entire note back to the creditor. So therefore, getting back to this halacha, the text of this halacha, if the escrow holder knows for a fact that the debtor did not mean to be taken seriously, and therefore he knows that he would be doing a disservice and would not be fulfilling the correct instructions by giving the note back to the creditor, then he should not give the note back to the creditor. But let's say, but let's say the escrow holder is unsure. There could be situations where it's not clear whether this was a clause that was meant to be taken or an escrow instruction that was meant to be taken seriously or not. Or he's not sure that maybe he knows what he's supposed to do because it's right there in black and white that it was not meant to be taken as an asmachta, but he's concerned that maybe he'll make that claim later in court. Because he's not sure that on the one hand, maybe it's an asmachta. On the other hand, perhaps the debtor really did mean to indebt himself for that full amount. Or another illustration could be is that the escrow holder knows that the debtor might have a legitimate claim, but he just doesn't know whether it's going to prevail in Beis Din or not. So you have all of these doubts as the escrow holder. You don't know whether you're doing the right thing, even though the escrow instructions say quite explicitly, give the paper back to the creditor, okay? So then Yasa, in any situation where the escrow holder is in doubt, Yasa hashlish kafi mashu hushlash biyado. What he should do is he should follow the escrow instructions. In other words, when both parties created their initial transaction, they gave escrow instructions to the escrow holder, and they said, you hold on to this, and if XYZ transpires, then give the note back to the creditor. Okay, that's what they tell him. And they make a kinyan, and everything is written in black and white and signed by both parties. And now, in a situation where there's a doubt whether perhaps this was meant as an asmachta, he's not sure what to do. So here's what this guy Levi, the shalish, the escrow guy, here's what he should do. He should follow the escrow instructions. Because he's not a judge. It's not up to him to make the call. Rak shalish, he's only an escrow. And if the debtor wants to make a claim that he didn't mean it, or he has a valid counterclaim, let him do that in Beis Din. In other words, this halacha is designed to sort of alleviate the stress on the escrow company. The escrow company should follow its instructions, and even though they know that there may be a claim against them, make your claim, go to court. I have to follow the escrow instructions. So the only thing that the escrow company should do in order to cover itself and in order to protect the interests of the vulnerable party is do everything in front of witnesses and basically demonstrate to the witnesses that these were our escrow instructions and we are following through on our escrow instructions, but we do recognize that there may be some gray area here. So we want there to be witnesses to what we're doing so that no one can claim that there was something, a foul that was done. The terem shiotzi enemy tachas yado yomar bifnehem eich ba'a hashlishus liyado. So before Levi releases the document back to the creditor, he should express to the witnesses how he was assigned, how he was appointed as the escrow, ve'al eza tanai, and under what conditions he was told to relinquish the note back to the creditor. The witnesses should then document everything, sign on it, the yitnuhu liyad hashalish, and then give that document, which it's a new document, but it documents what's transpired. Give that to the escrow company that says, and basically they're giving it to Levi, the escrow, and it basically gives him sort of the protection that he's looking for to make sure that he has done everything above board. V'hashlish yimserenu lahala k'sheyavo liton, and then the escrow person should give it now to the debtor. Should give that paper to the debtor, and he says, now you have the ammunition you need. Should you wish to make a claim against what has been done when we surrendered the notes to the creditor, you now have the ammunition, and you can show this to Beis Din. So as proof, if you want to be able to make your case to Beis Din. And therefore he can make his claims. He says, but what the shlish, the Levi fellow, the escrow, what he should not do is to bring it himself to Beis Din, to give it to the debtor in front of Beis Din. Because the creditor may object. He says he should not bring I'm trying to understand. Ein lashlish lahavi hashlishut lebeis din litna lazeh bifnehem ki hem lo yanicha lo litna lazeh shalom midat hala ol v'hala yacholiton ezetaina. Oh, okay. I'm sorry. This last statement means that the escrow fellow should not say, you know what, I'm not going to follow my escrow instructions. Let's just all go to Beis Din. He says, let's just all go to Beis Din and let the Beis Din sort it out. He says because the Beis Din will not allow the escrow person to follow through with his instructions without the consent of the debtor. And since they're going to wait for the debtor to make his counterclaim, why the escrow instructions should not be followed. And because the Beis Din is allowed to be concerned and even make claims on behalf of someone who's not present in Beis Din. Kol ma sheyuchal liton ba'atzmo. V'hashlishut lo nimsor lo al derech al das kach. Ela al das sheyitnena lemishi yiskal piatanai sheyisnu imo kishem masru alo. And the escrow company would be doing they would be doing a disservice to the creditor by doing this. When I give my paper over to an escrow company, I am not expecting the escrow company to say, "Well, we're not sure what to do. Let's let the court sort it out, and we're going to continue holding on to the paper." The creditor can claim that's not your purview. That's not your right to say that you're not sure what to do, so you're going to hold on to it and let it get sorted out in court. The creditor has a right to say, it's here in black and white that you need to follow the escrow instructions. Follow the escrow instructions, document it in front of witnesses, and if the other party has a counterclaim, then we'll sort it out in court without you. That's not your affair. In other words, essentially what this halacha is designed to do is to basically tell the escrow company what it should and shouldn't do whenever they have a doubt as to what the counterclaim against the escrow, that there might be a counterclaim against the escrow instructions. That's essentially what this halacha is. And basically what the Rav Shulchan Aruch is saying is follow the instructions that are there and do it in front of witnesses so that it's documented, so that if someone wishes to make a counterclaim, if the debtor wishes to make a counterclaim, he has the ability to do so. That's essentially what we're saying here. That's a good question. I don't know what the convention is, but either party can claim that you have to follow the instructions.
So when is this company makes a statement that this is an unfair deal or just an assessment?
So in our illustration, right, the escrow instructions were very clear that the debtor has agreed that if he misses a monthly payment, the creditor gets the promissory note back, the full amount for the full amount. And he can now take the guy to court and collect the entire amount in the promissory note. Or let's say he can collect the balance on the promissory note in one fell swoop. What rises in the mind of the escrow company, was this meant as an asmachta or not? Was it meant to be taken seriously or not? But the escrow instructions are clear and both parties agree to it. And it's not certain that it's an asmachta. It's possible. Sometimes there's a gray area. And that's what the Rav Shulchan Aruch is addressing here. If it's unclear to the escrow company whether it's an asmachta or not, then their duty, their fiduciary duty, is that's the term, is to follow through on the escrow instructions and let the court sort it out. And it's not usually both parties share in the cost of the escrow holder. That's usually what happens when you set up a deal like this. Both parties have to pay. Like whenever you use an escrow company, don't both the buyer and the seller have to divide the cost?
So they have to be for both parties.
They have to be looking for both parties' interests precisely, but they have to follow the escrow instructions. So if they're concerned that maybe the escrow instructions, there's some ambiguity, or they feel that despite the escrow instructions, the debtor may have a counterclaim, They should do everything. They should document everything in front of witnesses and say that this is what was done. Give a copy of the procedure that they followed to the debtor that they feel is going to sue, and let him take it to court. The escrow company should not, and this is what the Rav is saying, the Rav Shulchan Aruch is saying, they should not take the law into their own hands and say, we're not giving up the money until this goes to court. That's not their legislation. That's not their purview. Yeah. Right. You can do a repossession, a repo man. Right.
In that case, such a way that the purchase, the owner of the product can come repo without even doing.
Right, exactly. Right. So, and then if the fellow has a claim, so it could be, well, in a repossession, usually the owner hires a company to do the repossession for him. Right. That's not really an escrow company. They're hired to knock on the door, go into the person's house.
The bailiff.
Yeah, right.
The bailiff.
Right. The bailiff. Yeah. In Canada, is the bailiff a court appointee, or how does it work?
I didn't know.
Yeah. Okay. Yeah. So that's actually a good analogy, although it's not a perfect analogy. But it would be a good analogy, what Doug is suggesting. Anytime there's a repossession, what you're basically doing is you're taking back the entire product, even though the purchaser has already made partial payments. Yeah, he's made monthly payments, but once he misses, let's say, 3 months of payments, then they start the repossession process. Yeah. Okay. Okay. And that's what you essentially agree to when you purchase the item on layaway. They call it layaway here also. Okay. Correct. They have to be responsible in looking at the terms, and if they believe that there's a gray area, they should do what they feel is the letter of the law, the letter of the instruction, and then let the Beis Din sort it out afterwards. The next halacha says, "Aval im yadua l'shlish shezacha echad mehem b'hashlishut al pi hadin lefi ma shehitnu imo kishemasaru halo ve'en l'shekenegdo shum taina al pi hadin v'ha'emet yitanena lemi shezacha ba b'fnei Beis Din v'yafarish lahem inyan hashlishut." He says, if, however, it is clearly known, in other words, there's not even a shadow of a doubt in the mind of Levi, the guy who's the escrow person, that based on the terms of the deal, there's no ambiguity, there's no doubt, and we know for sure that, or I know for sure, because we could be talking about a single individual, I know for sure that Ruvain, the creditor, is entitled to get this promissory note back. So they should give it to Ruvain in front of Beis Din, explain to Beis Din what the terms of the instructions were. Vehem yichtavu v'yachtemu ha'inyan. He He says, and then at that point, Beis Din should sign off on it. Why? Ki shema yipol b'neihem achar kach ezo machlokes v'hakchasha. He says, because maybe if it's not done with that immediacy, then there might arise between the creditor and the debtor some kind of dispute later on, and the debtor will then claim that he doesn't owe the money to the creditor. V'hashlish lo yihiyeh neman az la'achar shetetzei hashlishut mitachat yado. And perhaps the escrow person will no longer be a party of interest by that point because he's already recused himself completely by giving up the paper. His instructions have already been fulfilled. He's no longer a party to whatever transaction is going on between them. And so the escrow company's concern is that they see that this debtor is potentially a litigious individual, and they're concerned for the sake of the creditor that if I just give the creditor the paper without recording it in court, then I'm worried that once I leave and I've fulfilled my instructions, then the debtor is going to sue the creditor, and I won't be able to testify. I won't be able. I won't be a party of interest that the Beis Din will be able to interview. Now, why is that? So the Imrei Yaakov, I think, will explain, Lo yeneman pirish ra ke'ed echad bilvad, because I'll only be like one witness. The bisman she'ashlishut biyado ne'eman kibeitrei afilu hukara ve'ein tzarach lishava. The Shulchan Aruch tells us something interesting. When Levi, as the escrow person, is holding on to the paper, his testimony is valid like two witnesses in court. But because he is essentially in a position where he's trusted equally by both parties. And since both parties have placed their trust in Levi, he has more believability power when appearing before Beis Din. But that's only so long as the papers are in his hand. Once he's relinquished the papers and fulfilled his escrow instructions, then he's simply a witness to what has transpired, but he's only one witness. And the Beis Din, therefore, will not be able to give him the same credibility that he would have had if he was still holding on to the paper. And therefore, in a situation where Levi is concerned that perhaps after fulfilling the escrow instructions, the debtor is going to pull shtick. He's going to, try to figure out some kind of legal loophole or subterfuge or things like that. Then the escrow person, Levi, should go directly to Beis Din and say, I would like to deliver the promissory note to Reuven in the presence of Beis Din, because I believe that this will protect Reuven from further litigation in the future. That's when Levi feels certain that Reuven is entitled to the paper, and he also suspects that Shimon, the debtor, is going to try to pull shtick. That's the second part of this halacha. So in a situation where the escrow company feels that it's possible that the debtor may have a claim, he should still fulfill the escrow instructions, but do it in front of witnesses and say, if you have issues where there are things that need to be sorted out, it's not clear cut, take it to Beis Din. You have our testimony of the witnesses of what was done, and let the Beis Din sort it out. But in a situation where the escrow person is certain, feels very confident that Reuven is entitled to the paper, and they're concerned that Shimon is going to try to pull shtick, then Davka, they should go to Beis Din. Levi should go to Beis Din, deliver the papers in the presence of Beis Din, explaining why Reuven is entitled to it based on the escrow instructions that are clear and unambiguous. And then this way, he's giving strength to the person that he feels is entitled to prevail in that case. Okay. So that's the basis of this halacha. We'll continue this in Mirz Hashem.